Tennessee Court of Appeals afternoon session. Obviously, I've got two experienced practitioners here, and I'm going to take just a moment, though, to introduce the panel and run over the basic ground rules. First of all, we have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg, and we'll be your panel this afternoon. As both of you know, you get 15 minutes to make your oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court before you begin your oral argument and after you introduce yourself. Obviously, the appellee gets no rebuttal time, but you may reserve up to 5 minutes of rebuttal time. I want to thank Mr. Hivner and his staff for putting this together. It's not a easy task to coordinate all these video oral arguments. I also want to thank the AOC technology staff for having the expertise to make all this work. And obviously want to thank the parties and the attorneys for participating in this. I don't know that it's a novel concept at this point in time, but it's still new to many of us, and we're trying to make the most out of a difficult situation. So we appreciate you working with us on this. So, Mr. Hivner, if you would call the first case, please.
Kerry Davis versus Garrettson Ellis, MD.
All right, we shall hear from the appellee, or the appellant, I'm sorry. I'm losing my mind today.
Gary Smith for the appellant, and I would request to reserve 4 minutes of rebuttal.
All right, sir, you may proceed.
This case comes to you on appeal from a grant of summary judgment in this healthcare liability case. And frankly, I hope I'm going to be fairly brief on this because I think the issue is very, very clear-cut. Trial court granted summary judgment on the basis that plaintiff's expert, Dr. Gunnarsson, had changed his testimony or attempted to change his testimony in a post-discovery deposition, post-motion for summary judgment by the defendant affidavit. And there's not any other way to express this other than that is not accurate. At no time did Dr. Gunnarsson ever change his affidavit, or excuse me, his deposition testimony, or his opinions. In the initial stages of discovery, we identified Dr. Gunnarsson as an expert who testified that there was a deviation from the standard of care by Dr. Ellis, that deviation caused harm that would not otherwise have occurred, including the death of Mrs. Davis. And at exhaustive length in the Rule 26 disclosure, the reasons for that were set forth, including the failure of a timely required intubation, which was not done. Interestingly, in the approximately 4-hour-long discovery deposition taken by Ms. Harrison, who I'll note is, and I mean this, a respected adversary, he was never asked that point-blank question. Did failure to timely intubate result in the death? The point-blank question was never asked, and therefore, what we have is the court granting summary judgment allegedly because a opponent did not answer a question that was never asked. But having said that, Dr. Gunnarsson's opinion that it was a deviation from the standard of care not to timely intubate and that it caused the death of Miss Davis is in his deposition testimony repeatedly as a result of other questions other than the linchpin question having been asked. And many of those occurred in response to questions that were about a hypothetical scenario that never occurred. But replete in that deposition is Dr. Gunnarsson's clear opinion that it was a deviation from the standard of care not to intubate timely and that failure resulted in the death. Now, some of those have been cited in our brief. Let me just point out a couple to you specifically. With respect to both standard of care and causation, the question was asked on page 126 by Ms. Harrison. It would be speculation to say the outcome would have been different if Dr. Ellis had intubated earlier. Answer, I disagree with that. In other words, he's saying that it is not speculation to say that the outcome would have changed if the intubation, which he makes clear should have occurred earlier, had in fact occurred earlier. He goes on with a virtually full-page explanation as to why he disagreed with that. And in other parts of the deposition, he expresses the opinion that had she been intubated earlier, she would have survived this multiple pneumonia that she was suffering from on more than one occasion. On page 167, keep in mind, in the judge's order, it says, starting on page 7, at no time during his deposition did Dr. Gunnarsson say the defendant's failure to intubate Mrs. Davis or the defendant's failure to have a plan more likely to not cause Mrs. Davis's injury. Remember now, what I just gave you a moment ago. Further, she says, without any explanation for his changed opinion and with no additional knowledge other than being aware of the content of the defendant's memorandum of law, Dr. Gunnarsson's affidavit presents an entirely different assessment of Ms. Davis. Unlike the deposition testimony, the affidavit emphasizes the question of untimely intubation. And then she goes on to say that intubation is not something mentioned as a deviation during the deposition. Well, he did say it in the deposition over and over and over and over again. So I don't know where that comes from in the judge's order. Also in the judge's order, she goes on to mention that his discussion about the plan, which was twofold. He said it would have been okay for Dr. Ellis to have initially tried the PPV, the positive pressure ventilation, on a trial basis. He didn't do it. But it was the opinion of Dr. Gunnarsson clearly in his affidavit that that would not have worked. It would have been okay to have tried it. But in his opinion, it would not have worked and she was going to require intubation. And the standard of care required it. On pages 167 and 168, he says that there are others than these, but specifically with respect to the standard of care on page 174 and 175, Ms. Harrison asked the question, after talking about there being risk of putting it on the ventilation. She says if there are risks, if a clinician can avoid that, that is part and parcel of the clinician's standard of care. The doctor says, yes, it is. But it is also part and parcel to that physician, in this case as an intensive standard of care, not to delay intubation when a patient is anticipated to fail or is anticipated to have impending respiratory failure. So the physician, in this case, the intensivist, is required for them not to delay intubation when the patient needs it and when the patient has impending respiratory failure, which is exactly what happened in this case. It is difficult for me to articulate where the trial court was coming from in that order, with all due respect to the court. Say that he did not talk about the failure to intubate and its relationship to the death in the case of the deposition is simply not what is reflected in that deposition. It is in there multiple times, though he was never asked point blank the magic question. I think at least got to mention in passing here, their alternative theory is that there was a superseding cause. I'll rely on our brief on that. Clearly, two of the four criteria for superseding intervening cause is that the ultimate issue not be related to the original negligence of the wrongdoer, which in this case, the delay in intubation satisfies that. And additionally, the fourth criteria is that it be a result that's not foreseeable. And Dr. Gunnarsson has addressed that extensively, but it's in Dr. Ellis's own assessment. He acknowledged it, and he left her that she was going to get worse and would likely need intubation within the next 24 hours, which clearly showed foreseeability. So that I will defer to any other questions the court may have.
Seeing none, we'll hear from the appellee.
Good afternoon, Your Honors. My name is Jennifer Harrison. I'm from the Memphis-Shelby County Bar, and I represent Memphis pulmonologist and critical care doctor Garrettson Ellis. To address a few things that my skilled adversary just mentioned to the court regarding Dr. Gunnarsson's post-summary judgment 5-page affidavit. If it didn't change his original opinions or didn't contain two new opinions, what was the point of it? So it did indeed. Regarding the Rule 26 disclosures, they were saturated with expectations that Dr. Gunnarsson was supposed to opine at his deposition in Michigan in a very cold February 2019. And I expected him to give those opinions, and those were my expectations of him, and he didn't. So what's laid out in the Rule 26 disclosures regarding timely required intubation at a minimum didn't hold water when we got to his deposition. A hypothetical that never happened. I'll be very clear. In almost 5 hours of deposition, numerous pages, we apologize for the length of that, and we still were of limited time. The word hypothetical, or any form of that word is not mentioned, not one time in the word index. Everything was specifically related to the care and treatment provided by Dr. Ellis, specifically to his patient, Ms. Davis. Intubation earlier. This is a little tricky, but not so much. Even Dr. Ellis testified. The reason she had a respiratory arrest is because they could not get her timely intubated. That is not disputed. When there was an attempt made roughly 7 hours after Dr. Ellis's shift left, when the attempt was made, 3 attempts go by. 26 minutes pass. Even Dr. Gunnarsson, plaintiff's expert, says her life is salvageable in the midst of these attempts to intubate her until she went for minutes without oxygen. She arrested because they couldn't get the tube in. That is an unknown in this case. That no one has alleged failure against the ER physician who came up and tried to intubate. She just was a difficult intubation. When I asked Dr. Gunnarsson, plaintiff's expert, appellant's expert at his deposition, what if the ER doctor had tried to intubate at 8:45? How do you know he would not have encountered a difficult airway? We don't know. What if Dr. Ellis had tried to intubate earlier? How do you know he would not have encountered the same difficult airway? We don't know. No one knows.
I'm sorry, counsel, was that Dr. Gunnarsson's response to that question?
I'm sorry, Judge.
Or that we don't know?
Which question?
The last one that you mentioned, where you asked, well, if he had attempted at 4, would it have been different?
His answer was he did not know. He said he has to speculate on these issues because he point blank says, I was not there. I don't know. And I don't know why Dr. Causey, the ER doctor, had difficulty. He says that the outcome may have potentially been different because she had, we'll call it oxygen reserve, potentially. Now, I will say, Judge Armstrong, that clear back to your, and plaintiff mentioned this, and appellant mentioned this in their brief. It was your case, the Duncan v. Ledford case, that their expert is all over the place and even contradicts himself. And your Duncan v. Ledford case point blank says the cancellation rule applies here. We're left with no evidence. But let me get back to the intubation. Intubation and the non-invasive ventilation. They're options. They're alternative methods, which Tennessee Pattern Jury Instruction 6.14 is going to go up regarding alternative methods and how a doctor's not wrong if he chooses his method when there are, other alternative methods. That's exactly how Dr. Gunderson dresses these up. He dresses them up as standard of care violations. In reality, they're alternative methods. That's what's in his deposition. Now, he did not speak with the Hornbook precision that appellant sets forth in their trial brief. He's not expected to. Although the 5-page post-summary judgment affidavit was about as close to Hornbook precision as you could get. But the trial judge was right. The affidavit changed nothing. Now, at oral argument, which we really didn't, Mr. Smith really and I didn't get to make because the judge excluded the affidavit at oral argument, but then she allowed it and said, even if it doesn't change anything, because there's no proof in the record that if Dr. Ellis had, one, attempted to intubate Ms. Davis before he went off shift at 6 a.m., that he would not have encountered a difficult airway and the outcome would have been any different. There's no proof in the record.
Is there anything in the medical record that indicates that at 4 o'clock that Dr. Ellis noticed anything that would indicate that there would be difficulties with intubing Ms. Davis at that time?
No, there is not, Your Honor. Good question, because he was asked that question at his deposition. Did he see any risks with intubating her other than the general risks inherent with sedating and intubating a patient? And his answer was no. The non-invasive pressure ventilation, 17 times in his deposition, the root word or some form of the word speculate, speculating, speculation, and Dr. Gunderson introduced this word into his testimony, unsolicited. I didn't say it. I picked it up and ran with it, and he ran with me. There is no proof.
Isn't it true that the speculation only went to whether or not the non-invasive treatment would have been effective?
As opposed to that is his testimony throughout the hours of his deposition. Yes, the outcome regarding the non-invasive ventilation, no one knows what the outcome. She actually did very well on it hours after Dr. Ellis went off shift. She did fine on non-invasive for over 2 hours. So I asked him, how do you know that if Dr. Ellis, based on how she did later in the evening, if Dr. Ellis had tried that, how do you know the outcome would have been any different? He said, I don't, I'm speculating. Those are his words. Okay, so
Counsel, you would agree that mechanical ventilation is more an effective method when a patient is having respiratory issues, that it's more effective than the non-invasive method?
Your Honor, with all due respect, no, sir, because the therapies have to be escalated. And I will tell you that Dr. Gunderson and Dr. Ellis agree on this point. You try the nasal cannula first, and then you try the mask. And if that doesn't work, you do the non-invasive therapy. And if the patient fails the non-invasive therapy, you are only left with sedating and intubating the patient and putting her on mechanical ventilation. So it's an escalation of therapy, if that makes sense.
Okay.
Okay. Now, let me back up and be clear. The non-invasive ventilation, this trial thing that may or may not have changed the outcome, he says it was part of a plan. He wasn't there. He doesn't know what the plan would have been. He had to speculate as to the plan. These are his words. He wasn't there. Looking back at the records, he had to speculate as to what the plans were going to be. Over and over and over, Dr. Gunderson offered, these are alternatives. These are options. These are within Dr. Ellis's clinical judgment. The plan that he says, the things that he says, it could have been this, or this could have been carried out. They were. Dr. Ellis left at 6 a.m. And after he left, there were 2 emergency room physicians, 1 pulmonologist, critical care doctor, 1 hospitalist, 3 ICU nurses, and 1 respiratory therapist involved in the care and treatment of Ms. Davis after Dr. Ellis went off shift. The plan was implemented. Dr. Gunderson's issue was with timing. If it had been implemented sooner, and then he says it may have changed the outcome. It could have changed the outcome. At the tail end of his deposition, he told me, if these things had been done earlier, it may have changed the outcome. Things could have been different. And that is clearly based on our precedent and our law, a lot of which I included in our brief. That is insufficient. As a matter of fact, what Dr. Gunnarson's affidavit did, based on his deposition testimony, there was no doubt. There was no doubt that plaintiff did not meet his burden. With the affidavit, what we ended up with was this metaphysical doubt that is insufficient. Mentioned in a string of case law, the non-moving party must do more than simply show that there is some metaphysical doubt as to the material facts. A plan. The plan did the same thing. It was Dr. Ellis should have communicated. Let me be very clear. Dr. Gunderson testified because I asked him, I couldn't wait to hear his answer for this. Does the standard of care require Dr. Ellis to write out a plan to the skilled ICU providers? No, that's not what I'm saying. But he had to relay it to somebody. Dr. Ellis was the medical director of the ICU at Methodist Germantown when he wrote these orders, when he provided care and treatment to Ms. Davis. And the ICU team knew exactly what he meant when he documented his assessment and plan to titrate oxygen to maintain our saturations. They testified to this. The two ICU nurses testified to this. They knew exactly what he meant. They knew exactly what their role was. There were 3 failed intubations when the attempt was made. When she failed the positive pressure ventilation, she failed it after 2 hours. Attempts were made to intubate, and then she arrested. This is where my superseding argument comes in. If this court finds that there was a violation of the standard of care and that somehow caused an injury, including Ms. Davis's death, that there was a superseding intervening cause that breaks the chain of causation for Dr. Ellis. It occurred.
Is there any proof in the record that she died because of the failed intubation? Or did she die because of lack of oxygen or no reserve at the time of the intubation? What's the proof in the record?
The proof in the record, Your Honor, is they did an autopsy on her, and it's bilateral confluent pneumonia. It's a string of words that get complicated, but there is nothing in her autopsy that says she died because she didn't have any reserve. And Dr. Gunnarson's testimony on that is that if she had had this reserve and attempts had been made earlier, potentially could have changed the outcome. This all assumes that Dr. Ellis, if he had elected as an option to intubate, if he had chosen that in his clinical judgment as one of the options that Dr. Gunnarsson provides, this all assumes that he would have been successful. And Dr. Ellis actually said, if it happened to Dr. Causey, it could have happened to me. Dr. Gunnarsson agreed with that. Dr. Ellis could have found himself in the same situation with a difficult intubation if he had chosen that route.
Let me make sure I understand your answer to my earlier question. Does the autopsy show that she died because of failed intubation?
No, those words are not, no, Your Honor, those words are not in the autopsy.
So we can't assume that that's why she died then, because of the 3 failed attempts at intubation at 11 o'clock, some 7 hours after she'd been seen by Dr. Ellis rather.
That is fair, Your Honor. But what we can say is that there's language differences between respiratory arrest and respiratory distress. She was in respiratory distress. She had a respiratory issue that put her in the ICU because Dr. Ellis walked her over there to make sure she got intensive care care. But she did not have a respiratory arrest until the 3 attempts to try and intubate her, and Dr. Gunnarsson agrees with that. He gets sideways about it in his deposition, but when I point blank asked him, he agreed that she arrested because of the 3 failed attempts to intubate her. She was salvageable. Her life was salvageable up until those.
And where would I find that in the transcript of his deposition that he agreed with that? Because I didn't see that in reading the deposition transcript.
Bear with me. It is in my brief, forgive me, and now I'm down to the wire. Forgive me, Your Honor. It is, I have it, and under this sort of pressure, I cannot find it, but it is, he agreed with me. He absolutely agreed with me. I want to be clear while I'm trying to answer your question that can and could are found over 100 times in his transcript, and pursuant to Kilpatrick, that is simply insufficient, and a clear reading, obvious reading of his deposition changes nothing about the trial court's order. Thank you.
Okay.
All right. Judge Armstrong, any other questions?
No.
All right. Mr. Smith, we'll hear from you in rebuttal.
Dr. Gunnarsson testified to as the cause of the arrest was she was allowed to become hypoxic and went into respiratory arrest. I stand to be corrected on this, but I don't think I will be. That at no point in that deposition did he concede that 3 failed intubation attempts caused respiratory arrest. He also made it clear on all these times that he used the word speculation. 2 points need to be made here. That was in respect to talking about things that did not happen, that Dr. Ellis did not do. But importantly, the second point is that it was his opinion when asked the question on page 26, 126. Is it speculation to say that Dr. Ellis could not have found himself in the same situation with a difficult airway when he was at the bedside as Dr. Kelsey found himself in? Same situation. It would be speculation to say the outcome would have been different if Dr. Ellis had intubated earlier. Answer, I disagree with that. And then he went into a long explanation, which was repeated several times through this deposition, as to why he did disagree with it. So when he used the word speculation, it was to show that it was medically probable that the outcome would have been different. That's exactly what meets the standard that he's required to meet. And no, there is no proof that whatever it was that made the intubation difficult 6 hours later was present before. Dr. Ellis admits that. What we know for absolute certain is at the time that the difficulty in intubation was encountered, she was in arrest. Of course, you're going to have difficulty intubating. And that was part of the point that Dr. Gunnarsson made. You don't let the situation, which you've already predicted, if you're Dr. Ellis, is going to occur. She's going to continue to get worse. She's going to need intubation. So you don't wait until it's an emergency to do that. You do it when it's not emergency and when she's got reserve. He emphasized over and over again that even if there had been a difficult airway, when she's got reserve, she can accommodate that. That did not occur. One thing that I would disagree specifically about with Ms. Harrison was that the questions that resulted in answers like could or maybe were restricted to what actually was done. A reading of this transcript will show that, if not without exception, virtually without exception, every time that Dr. Gunnarsson used those words, it was done in respect to modalities that Dr. Ellis did not do, not what actually was done. Thank you. We ask that the court reverse this order, reading of Dr. Gunnarsson's transcript and comparing it to the actual findings made in the judge's order. Do not square.
All right, counsel, we appreciate your argument. We again thank you for participating in these video oral arguments. We appreciate Mr. Hibner and his staff and what they're doing to make this work, as well as the AOC technology staff. We will take this matter under advisement and attempt to get you an opinion as quickly as possible. Mr. Hibner, if you will recess court till the call of the next case, please.
This honorable court is now in recess until 2 p.m.